Welcome to 181st episode of AAA Weekly Webinar Series. We have already completed 180 webinars on Zoom platform and we have seen live audience. However, the trend which is in vogue today is the recorded, and that too as a discussion and deliberation. So today onwards, we are starting all the episodes which would be released every Saturday at 11 a.m. duly recorded, edited, and also it will be in the form of discussions and deliberations. So I'm Anil Goel, founder of AAA Insolvency Professionals, and we have Ankit Goel, founder of AAA Insolvency Professionals, and we would be deliberating today on the very important and controversial issue of what are the rights of Provident Fund Department, what are the rights of workmen on gratuity, and what are the present provisions of Superannuation Fund. Because this controversy is leading to a lot of litigation. The EPFO, the Employees Provident Fund Organization, is raising demands against all those companies which has gone into CIRP or in liquidation. Most of the resolution professionals and liquidators, they are struggling how to handle these notices, show cause notices, and demand orders that they are issuing under Section 7A of Provident Fund Act during CIRP and even during liquidation. So this is what we are going to discuss. Ankit, I think you have a lot of questions in your mind. How would you like to start?
So I would first want to say that this new format that we have started helps us continue our commitment every Saturday to be with you. We would also share the way we can get your feedback and the way we can make sure that our video addresses all the questions, and we can also take feedback and comments from you. Before I go forward, I would like to say that this issue with respect to PF, gratuity, superannuation related matters, they have been something that have been bothering us also in all our cases. And yes, another study that whenever we touch back on this topic, we find something new which is available. So I believe we first need to share with our audience that what is the broad framework in IBC regarding treatment of PF, gratuity, and superannuation employee benefits. And we can first talk about maybe the pre-CRP related dues, and then we can deal with the post-CRP dues.
Very right, Ankit. In case we see the Provident Fund and Gratuity and Superannuation Fund, these are the social welfare benefits for the workmen and employees. So these are a kind of lifeline of an employee. It is not possible that a person who has worked for say 30, 40 years in a company and that company goes into insolvency and he loses that provident fund that he actually has been getting deducted and the employer is also contributing, he cannot lose that provident fund, he cannot lose that gratuity, and in case there is any fund in the superannuation fund, he cannot even lose that because that is the backbone of his life. So therefore, right from the beginning, it is very important that we should understand that once we say that it is backbone of India's labor welfare scheme, we also need to see what exactly the Constitution says. The Constitution, the roots actually it's a directive principle of the state policy. I am actually trying to read that even the Constitution, Article 38, 39, 41, and 43 talks about it. Then we also can see that this Workmen Compensation Act 1923, Payment of Wages Act, and also the international influence, in fact, this Employees Provident Fund and Miscellaneous Provisions Act 1952 was promulgated, and this was basically a compulsory saving and the matching saving will be contributed by the employer. That can be used by the employees at any time during lifetime whenever he finds a need of funds. So this is the Provident Fund. And then we talk about the gratuity. The gratuity is also something which is a statutory terminal benefit. It is given to the employees in case he completes 5 years in an organization, and there is a calculation, and it is also considered as a retirement benefit. So nobody can think of losing gratuity in case the company goes into insolvency. The company might not have taken an insurance policy. The company might not have deposited this amount into any gratuity fund, but this amount is due to employee, this amount is due to workman, and there should not be any law in this country, may it be insolvency or any kind of stress. The gratuity should be paid to the employee because that is something that he earned in the last 30, 40, or even whatever the lifetime that he has worked with that company. So the intent is very clear, but somehow it was not properly captured in IBC. The Supreme Court of India, in various judgments, have in fact decided in favor of workmen and employees with regard to EPFO, gratuity, and superannuation fund. What they have decided, that one provision in section 36 which says that any amount lying in gratuity fund, provident fund, or superannuation fund would not form part of liquidation estate. By using that particular line, the Supreme Court has decided in CIRP and in liquidation that the gratuity and provident fund dues has to be paid. So this is a broaderly, like we can say that there is a Supreme Court in fact protected the rights of workmen and employees broadly.
So we understand that this broad protection has come in, but when we compare this with other laws like SURFACI, and we look at secured creditors realization from IBC process and secured creditors realizations from the IBC or versus SURFACI, then I believe that IBC loses because at several occasions we find that gratuity liability is there, PF liability is there, and the Supreme Court's jurisprudence today says that the money to secured creditors will be cut to that extent.
No, Ankit, SURFACI law is not about resolving a company or liquidating a company. SURFACI law is only about kind of realizing out of the security interest. So when the bank realizes out of the security interest, whatever collateral security or primary security they have, in case they enforce their rights and they sell that property and recover their dues, that means the company is still continues with the directors. Company is still continuing. The obligation of the company to pay gratuity and provident fund continues with the promoters. So those promoters, they are liable to make payment of gratuity. They are liable to make payment of provident fund. In case they are not able to do that, then they will face all the provisions of law under the Gratuity Act, under the EPFO Act, and they will have to face that. However, in the case of liquidation, now the liquidator is having all the control and custody, or the RP is having all the control and custody. The resolution applicant would definitely want that he should get this clean slate. So therefore, the difficulty is only in CIRP or in liquidation, not in SURFACI. SURFACI, some bank will take away his asset. That doesn't mean the company has got any kind of waiver on the obligations. The company will not get any waiver on the obligations. The company will have to make this payment, or in the case of PFO, even there are provisions for imprisonment. The people who are not able to pay these obligations, they will have to face imprisonment also.
So when it comes to Section 14 moratorium, how does this offer relief to the companies under CRP where PF, gratuity, and other dues are involved? We need to understand the effect of Section 14 on PF, gratuity, and superannuation related dues.
So, Ankit, let us understand section 14. The section 14 actually says that during moratorium, the no proceedings can take place against the corporate debtor. And the proceedings also include assessment proceedings. So there are judgments, and I will just read a couple of judgments, which says that during CIRP, even the assessment proceedings for making assessment of income tax liability, for making assessment of GST liability, for making assessment of any other tax liability, or even making assessment of any EPFO, Provident Fund liability, that assessment cannot be made. So when the assessment cannot be made, that means that the dues of Provident Fund that as on the date of commencement of CIRP, that is certainly payable in full to EPFO, but they'll have to file a claim. And the claim would be for all those demands and dues which exist as on the date of insolvency commencement date, and not after that. EPFO presently is in fact issuing a lot of notices. Whenever they see the company has gone into a CIRP, they will start assessing or they will start investigating, and they pass order under section 7 capital A of EPFO Act. So that is something which is not lawful, and there are judgments. In fact, the judgments says the various judgment I can say. In the case of Pankaj Shah versus EPFO, NCLAT in fact said on very recently on 3rd of September 2025, any claim must be based on pre-CIRP assessments and filed with the RP within the prescribed timeline. This judgment dated 3rd of September 2025, very latest judgment, and it is in the case of a corporate debtor, namely Prem Shri Prime Properties Private Limited, and it actually states, NCLAT states that PF dues are sacrosanct in substance, but EPFO cannot create or inflate them through fresh assessments after the CIRP moratorium starts. Any such post-CIRP assessment cannot power a claim in the resolution process. Another judgment, which is again dated 8th of September 2025 from NCLAT, it is in the case of RPFC versus Vanita Maheshwari, and it is in the case of corporate debtor Bloom Decker Limited. Now, this appellate tribunal says that though PF dues are protected, EPFO cannot initiate or continue assessment proceedings once CIRP and moratorium begins. Even pre-CIRP dues assessed through post-CIRP orders are inadmissible. Upholding NCLT's view, the appeal was dismissed. The appeal was filed by Regional Provident Fund Commissioner and it was dismissed. Similarly, in the case of Department of State Tax versus Reliance Communication Limited, NCLAT decided on 19th of September 2024 that the State Tax Department filed claims during CIRP based on a subsequent assessment order. NCLAT admitted only the pre-CIRP claim, rejecting the later one, since it arose post-initiation of CIRP and after COC approval of the resolution plan. NCLAT upheld this view, holding that such subsequent claims cannot be entertained once CIRP has commenced and a plan is approved. The appeal was dismissed. So this is the situation as of today. As far as the Provident Fund dues are concerned, the Provident Fund Department cannot create fresh demands after the insolvency commencement date. And this is almost a settled law. However, if there are claims, the Supreme Court has already held that it has to be paid in full. It cannot be clubbed together with the secured creditor.
So today, in case we talk about in a nutshell with respect to PF, we will find that till the CRP commencement date, we will have the pending EPFO dues or pending dues towards the EPFO coming in as a claim. the PF department will file a claim and say that this is the PF or Provident Fund that was deducted or supposed to be deducted by the organization till the CRP commencement date, which they have not paid or deposited to the EPFO, and this is what is payable to them. Gratuity, I understand that till CRP commencement date, gratuity will also be in a similar fashion be calculated or computed for by the employees who are continuing in the company. They will calculate the gratuity that is accrued to them based on the number of years that have elapsed till their commencement of the CRP, and they will calculate that gratuity, although it is not accrued and payable or it is not due to be paid, but they will still claim that, so that in case the company is being continued as a going concern by the resolution applicant, then the resolution applicant can treat that gratuity liability. The resolution plan can either say that I am settling this gratuity liability in this manner, or the resolution applicant can say that I will continue the gratuity liability and I will pay the gratuity liability as and when it is due towards these employees when they retire at a later date or when they resign at a later date. So this is what gratuity will be treated as. With respect to superannuation, I believe again, if the company has a superannuation policy, then they have deducted some, they've made some contribution towards superannuation funds. That will again be something that will be here. I also understand that where company has contributed towards a gratuity fund, there is a process that larger companies where the gratuity liability is larger, the promoters, the directors, to protect themselves, they create a gratuity fund with LIC or any other agency. Similarly, they will of course be depositing the PF to the EPFO, and they will also perhaps be having a superannuation fund. So in case they've made some deposit in that fund, then I believe that that fund will be, the amount in the fund will not be disturbed, and the claim versus the fund, if the claim is excessive, only then there will be some claim that needs to be treated as the company's liability.
So I will just add what you said regarding gratuity. Technically, gratuity becomes due on the retirement of an employee or leaving that organization where he had worked for more than 5 years. Then the gratuity is payable, otherwise the gratuity is not payable in case the employee is continuing. Practically, when a resolution plan is submitted by any PRA, in that resolution plan, he should provide for the gratuity obligations of the company. Either in case he is continuing with all the employees of the company, he should say that yes, all the gratuity liability he would continue. Or he will say that all the liabilities of the existing employees he would crystallize and it should be paid in full, because the Supreme Court says that it has to be paid in full. Nobody can say that it will be there will be any haircut on the gratuity. So it is important that either the company should have the information about the gratuity liability of the company, or employee should file their gratuity claim. Why? Because it should be part of the information memorandum, it should be part of the resolution plan, and the resolution, a successful resolution applicant must deal with the gratuity claims or gratuity obligation, even if there is no claim filed for the gratuity. But the resolution professional is under obligation to discuss about gratuity obligation of the company in the information memorandum. Based on the information memorandum, the resolution applicant will provide in the resolution plan. So either it will be paid in full or it will be adopted for future payment. So that is what is the scenario in the CIRP. However, in liquidation, there is an assumption that on the date of liquidation order, it would be assumed that all the employees and workmen are discharged from their obligation. In case they are continuing, or some of them are continuing only in a scenario where the company is being kept as a going concern and the operations are going on, then they again, I would say, they should again claim, they should file their obligation, gratuity, or the successful bidder. Even if the company is being sold as a going concern, the successful bidder should definitely own that gratuity liability. Either it will be paid or it will be taken over for future payment. So this is what is the gratuity obligation in liquidation process. Regarding superannuation fund, it is more or less contributory, and if there are funds in the superannuation fund, that would not be touched. That is outside the liquidation estate. And in case the company within the balance sheet is also maintaining a superannuation fund, which is probably it is not permitted, because this has to be permitted by the income tax department. It has to be approved by income tax department. So we couldn't see a scenario where these funds are within the financial statement, within the balance sheet of the company. So therefore, the superannuation fund is easier. If there are funds, those will be protected from insolvency or from liquidation.
So next, I believe that we can talk about what do RPs and liquidators do in case they get a notice where the PF department wants to investigate or initiate investigation when the CRP starts or when the liquidation starts. So the first step, of course, would be to, I believe, share these judgments that we have talked about with the PF department and say that such investigations are barred under the moratorium. Let's assume that maybe they will continue their proceedings and the investigation report will be closed. So, of course, with respect to investigation, in case there is support and there is cooperation from the directors, the RP can also choose to continue with the investigation authorities, provide information in protest, saying that yes, this is the information, but yes, we protest that this is an illegal process. And when the order comes in where some investigation has been closed and some demand has been raised, then I believe that we need to understand that as soon as that happens, the next step should be to file an appeal before the NCLT, file an application in the NCLT. Should they go to the industrial tribunal and appeal against the PF order under the law that provides for an appeal being possible within the EPFO Act? What should be the next process?
So one thing is very clear based on NCLAT judgments, that the fresh demands cannot be created, fresh orders cannot be made during CIRP, and then those orders which are presently being made under Section 7A of the Provident Fund Act, those cannot be made. Any Provident Fund dues as on the date of CIRP, that has to be paid in full. And for that, the EPFO or any regional Provident Fund commissioner will have to file their claim. Now, even there are judgments that if there are dues and the claims are not filed, even then, I would say that it is the obligation of the resolution professional to mention that in the IM, so that the resolution applicant should deal with that, fully understanding that the EPFO dues as on the date of insolvency commencement has to be paid in full. So the resolution applicant will provide in the resolution plan for making that payment in full. In case such notices come, as Ankit said very correctly, there is no need to annoy the department. Whatever information they are seeking, in case that information is available, the RP should provide that information to the EPFO. And in case any demand is raised, in case any order is passed, and in case any claim comes, that should not be admitted. That should not be admitted. So that should, and then the EPFO will go to NCLT and then NCLAT, and finally this kind of decision will take place, that they should not have even continued with the assessment proceedings. So in case they have done that, their claim cannot be admitted, because the CIRP, we can only admit claim for all the dues which exist as on the date of insolvency commencement date. So therefore, the resolution professionals or the liquidator, if they have the information, they can provide the information to the EPFO department, but they should not be disturbed with such kind of proceedings, because it will not disturb their resolution process and it will not disturb their even liquidation process.
So that's good. So I believe that maybe to give you a brief, we have these central industrial tribunals that need to be that are the we call it. So to clarify this, central government industrial tribunals come labor courts. This is what is the jurisdiction, or this is the place where you have to go in appeal to the EPFO orders. And as I can see, there are about 22 of these in different areas, and they have different jurisdiction. It's a structure very similar to that of NCLT. So this is one where an appeal can be filed against an EPF order. And of course, when you reject the claim, the PF has a right to approach the NCLT and say that yes, the claim has been rejected. We had done an investigation report, and that's when you can also give a defense that this investigation report was done during the period of moratorium and it was not legal.
I think you are absolutely right, Ankit. In case there is any claim which is received based on an order and that order was passed before the insolvency commencement date, that also can be appealed. In case it is within the within the limitation period, the RP should try to crystallize the demand. RP should actually file an appeal and should try to understand whether that particular demand is illegal or illegal. So in case the RP does that, that means that the RP is saving a lot of money for the creditors. Because see, the EPFO's order, if it is not a good order, then the appellate tribunal will delete the demand or reduce the demand. So that effort should be made only for those orders which are passed before the commencement of insolvency and are still appealable and are not barred by limitation. We also would like to say finally, what are those judgments where the Supreme Court has decided that the EPFO will get their dues and the gratuity dues are supposed to be paid in full. So these are the judgments that we would like to say in this episode. One, that in the case of State Bank of India versus Moser Beer Karamchari Union, this is a Supreme Court judgment dated 7th of February 2023, and it is in the case of Moser Beer India Limited. The Supreme Court reaffirmed that EPFs, Employees Provident Fund, pension and gratuity dues are statutory and sacrosanct in nature. Such dues cannot be waived, reduced, or extinguished under a resolution plan. They must be paid in full, independent of other creditor claim under the IBC. Now, however, any claim submitted after, this is not COC, this is not the Supreme Court which has said this particular sentence that I am saying, it is only because of the NCLAT orders, which actually has come even after the Supreme Court judgments. Any claim submitted after the COC approves a resolution plan is typically barred, or after the commencement of CIRP, even that is also barred. The plan, once approved by the COC, is binding on all the creditors. Even statutory PF dues must be filed in time, means the claim must be filed in time. It has been repeatedly held that no claims can be submitted at a belated stage, especially after approval of the resolution plan by COC. Supreme Court, in fact, the Ghanshyam Mishra versus Edelweiss ARC, that was also a wonderful judgment. In that judgment also it was held that the EPF claim have to mandatorily be presented to the RP prior to the acceptance of the plan. So even in the case of EPFO versus Amit Gupta, liquidator of Hindustan Doroliver Limited, this judgment is dated 14th of October 2024. It was agreed that Provident Fund money does not belong to the corporate debtor. It means employees' Provident Fund is sacrosanct and it cannot be touched, reduced, or distributed like other claims. It also stated that the PF dues enjoy absolute statutory protection, no haircut, no compromise, full payment only. So this is the basic substance, that PF dues are sacrosanct, but claim has to be filed. It has to be a due as on the date of commencement of insolvency. So even in the case of Dalmia Cement Bharat Limited versus EPFO, And that is again a recent judgment from Bombay High Court, which is on 29th of April 2025. It is in the case of corporate debtor Murli Industries Limited. Concerning the CIRP of the corporate debtor, the court held that Provident Fund contributions are trust monies and not assets of the corporate debtor. Hence, outside the CIRP estate, such dues cannot be extinguished under a resolution plan or subjected to the clean slate principle, even if. So this is something which is that's something even if the EPFO does not file a claim, but in case the RP has the information, in case the RP gets the information about PF dues, it has to be mentioned in the IM information memorandum, and the resolution applicant will have to deal with it. That is what even decided by the Bombay High Court. The dues must pertain to a period prior to the insolvency commencement date, and these dues must be payable even before that. The demand must have been created before the insolvency commencement date. That is very important. Yes, Ankit.
So I believe that should take care of. So I believe that should take care of many questions that. So I believe that should take care of many questions that our participants would have with respect to recent developments in PF, gratuity, and superannuation related claims. And I believe that this will give more clarity to all our audience with respect to steps that they can take to make sure that they are in compliance with the current jurisprudence on this issue.
See, there are a couple of more recent judgments that we would like to share with the our listeners. One is the Bank of Baroda versus Regional Provident Fund Commissioner, and this is a judgment from NCLAT Chennai, and this judgment is dated 4th of June 2025 in the case of Supreme Coated Paper Board Private Limited, and the issue was whether the liquidator could trim EPFO claim of 3.99 crore, citing moratorium, lack of details, and computation issues. The tribunal, the appellate tribunal, held that Provident Fund contribution, interest under Section 7Q, and damages under Section 14B form a single statutory liability under Section 11, subsection 2 of the EPFO Act. Such dues must be paid in full in liquidation with priority over creditors and cannot be reduced by objections. Accordingly, the bank's appeal was dismissed and EPFO's entire claim was upheld. Now, this deals with two things. One is there are Provident Fund dues, and the order is passed under Section 7, capital A of the Employees Provident Fund Act. Second is the interest which is being charged by EPFO under Section 7Q, and that is the interest, and apparently it is also known to us that this kind of interest is also paid to the workman. So therefore, we also understand that the dues as well as interest is basically workman dues. And then there are damages in case of any employer is not adhering to the provisions of law again and again, then there are orders for charging damages from the employer. But this NCLAT Chennai says that all these dues are part of the statutory dues and cannot be diminished or cannot be reduced, or there cannot be any haircut. It has to be paid in full. Then we also have some kind of judgment in the case of EPFO versus Jaykumar Pasumal Arlani. It is an NCLAT judgment, NCLAT judgment, dated 3rd of January 2025, and it is in the case of Decent Laminates Private Limited. And the issue was whether Provident Fund interest under Section 7Q and damages under Section 14B already admitted in CIRP must be provided in the resolution plan. NCLAT held that Section 7A, Section 7Q, and Section 14B together form PF dues and cannot be split. It directed the successful resolution applicant to pay 75 lakhs of rupees as interest and permitted the application for waiver of damages. Before EPFO board. And this is what was said by the NCLAT, that you pay the interest and you file an application before EPFO for waiver of damages, citing the unavoidable reasons, because this company was under stress and the company was under insolvency. So that was the judgment. Again, it is so what exactly is now saying? So most of the judgments are saying that these are sacrosanct. Claim has to be filed. What is sacrosanct? The dues which are pertaining to a period prior to insolvency commencement date. In another judgment, which is very important judgment in the case of Sunil Kumar Jain versus Sandesh Bhatt, this judgment is from Honorable Supreme Court, dated 19th of April 2022, and it was in the case of ABG Shipyard. The Supreme Court held that only wages of the employee workmen who actually worked during CIRP form part of CIRP cost and first priority under Section 53. So the wages of non-working employees falls under section. So this is for the PF, gratuity and pension fund are excluded. It was also held in that case that in liquidation, the Provident Fund, gratuity and pension fund are excluded from the liquidation estate and it has to be paid in full. That was also held by Honorable Supreme Court in the case of ABG Shipyard. So, Ankit, anything that you still find, this is regarding gratuity also, this is regarding the Provident Fund also. So, we have seen, I think there are a couple of more judgments that we would like to discuss. Do we have that much of time, Ankit? We can conclude that Provident Fund dues, as on the date of insolvency commencement date, are supposed to be paid in full, no reduction, no haircut. Similarly, if the interest under Section 7Q is also payable in full if that claim is submitted on time and if the dues are pertaining to a period prior to commencement of CIRP. Third, for the purpose of damages, the liquidator or the resolution professional can approach EPFO organization for waiver. Even if it is a liquidation case or it's a CIRP, it has to be paid in full, but the process of raising further orders, creating more demands during CIRP or liquidation, that is not valid. So the resolution professionals or liquidator, they should actually give a reply that there are so many judgments that the assessment proceedings cannot start during CIRP. So therefore, these proceedings may be stopped. So this is all for Employees Provident Fund, Gratuity and Superannuation Fund, with latest judgments, with Supreme Court judgments, with NCLAT judgments. I hope you must have liked this deliberations, and in case you have liked, please do subscribe our channel, which is named as AAA Insolvency, and it is on YouTube. Also, our email is given in the description. If you have any query regarding this, please do send us an email. We can take up your assignment. We can even represent you before the NCLT, NCLAT or even Supreme Court. Our law firm can do that and our insolvency firm can even provide you all the services. Thank you.